Welcome and this afternoon at the HR Quarterly Update of Pallas Employment Lawyers. I'm Sanne van Ruitenbeek and I'm here together with my colleague Julianne Blok. Today we're going to discuss a few topics with you. We will start with some news and updates on temporary workers. The second topic we'll discuss is the Works Council Act because it's 75th anniversary this year. Then we will discuss the do's and don'ts in case of dismissal for underperformance, and we'll end with employer's liability. If you have any questions, please write them in the chat, and by the end of this webinar, we will deal with those questions in the Q&A as much as possible. Okay, then we will start with the provision of temporary workers. What will change? There is a new legislative proposal because the government wants to prevent or at least reduce the number of staffing agencies which do not respect the employees' rights. This legislative proposal has been adopted by the Parliament already in April, but is still pending approval by the Senate. If the law comes into force, what we do expect, it will come into force by the 1st of January 2027. There will then be an admission requirement, mandatory, by the 1st of January 2028. So we have still some time, but it's important to already know what is coming up and to start preparing for that. So what does this act entail? An admission requirement will be introduced. This means that only companies listed in a public register may supply temporary workers, and such application must be submitted to the Ministry of Social Affairs and Employment. So, what are the requirements of this admission? Well, the company, so the staffing agencies, should submit a certificate of good conduct for legal entities, but also proof of financial security over 100,000 euros, so they are clearly able to pay their employees the right amounts. And they should also provide a confirmation of compliance with labor legislation, tax and social security laws, and employment rights under the WADI, which mainly relates to equal pay. But there will also be some obligations for hirers. Hirers, so maybe your company also working with temporary agency workers, will have to verify whether the agency you are working with is registered in this system. Because if you will work, it's not allowed to work with agencies who are not registered. So it's important to verify this. And as a hirer, you have the obligation to provide information to the agency about the applicable pay and working conditions to ensure equal pay for temporary workers. So what is equal pay? Temporary workers are entitled to the same essential employee remuneration, so equal to those of comparable employees at the hire. We have a recent Supreme Court case where the court made a decision about this definition, which is really important for our practice. In this case, a temporary worker did not receive certain bonuses which were awarded to his colleagues. And the Supreme Court rules that temporary worker was entitled to these benefits. The essential remuneration, which also needs to be paid to the temporary workers, must be interpreted broadly in accordance with EU law, according to the Supreme Court. This will have practical consequences for temporary agencies and the hirers, because there is a risk that temporary workers may file claims for back payments, depending on the pay practices applied. Perhaps not in all situations, the temporary workers were paid the right amounts. And what is also important in this respect to understand is that the definition of equal remuneration, or the hirer's remuneration under the collective labor agreement for temporary agencies, may not be fully in alignment with the EU interpretation. So this may result into discussions about this later on. So the key takeaways of this topic are that it's important to verify whether the correct hirer's remuneration, the equal pay, is being applied in your company. And also to confirm whether your temporary workers agency will be registered once this requirement becomes applicable, but also maybe already to check whether they are making preparations in terms hereof, so that they are indeed a temporary workers agency you want to work with. Then we will change to the Works Council Act. Julian.
Yes, thank you. Good afternoon, everyone, and nice of you to join us. Today, we wanted to speak with you about the Works Council Act, the Dutch Works Council Act, because of its 75th anniversary. Of course, we are not able to discuss the complete Works Council Act with you today, because that will take the whole day, or at least the whole afternoon. I would be able to speak about that, but we wanted to give you some takeaways about the Works Council Act and how you can work with the Works Council Act, and to be mindful of certain topics which we know from our practice go not as smooth as it should be in a lot of cases. First, good to know that it's 75th anniversary, so 5 years after the Second World War, the Works Council was introduced in the Netherlands to create further employee involvement and influence with organizations. And the Works Council Act required employers to establish a Works Council consisting of elected representatives of the employees. But in the beginning of the Works Council Act, that also included the employer. So the employer was at the beginning part of the Works Council. This is of course not the case anymore today, but it gives a nice perspective how the Works Council Act was established at first. The Works Council was also given advisory and co-determination rights, right of consent in various areas, and also along those 75 years, the Works Council got more rights to go to court and to take serious actions. And nowadays, due to the cross-border activities that a lot of employers are performing, or are within a group, an international group with, for example, the shareholders or the headquarters is in another country than the Netherlands, we see, or I see in my practice, that a correct Works Council process in the Netherlands is very important to take into account, and doesn't happen always as it should be. The basics, a Works Council needs to be established if normally at least 50 persons are working at the company. If there are 50 until 100 persons, 50 persons, 3 employees need to take place, at least 3 employees need to take place in the Works Council. 50 to 100 employees working normally at the company, that means 5 employees, and 100 to 200 means 7 employees at least, and so on. Persons working for at least 3 months shall be eligible to vote and also to stand for election. So quite fast an employee is able to enter to be elected into the Works Council if there are, of course, elections. For today, I wanted to focus on some legal rights. Some of the key legal rights of the Works Council are Article 23, the right of initiative that the Works Council has. So the Works Council can take initiatives and bring them forward to the company, to the entrepreneur, being mindful of the company and of course the employees working in the company. Article 24 includes the right of consultation meetings with the company or with the director. And within that right, there is another important right for the Works Council, which we will discuss later on. Article 25 is one of the more important rights, the right of advice about certain topics. And Article 27 includes the right of consent. That means that for certain topics, the employer is only allowed to establish certain policies if the Works Council gave its consent. If the consent was not given, then a whole other process needs to take place. Today we will not focus on the right of consent, and I wanted to focus on the right of advice because this is a topic in which a lot of cases, especially in international cases, gives some more concerns. But before we discuss the right of consent and the Works Council process, it's good to know that the Works Council also has the right to engage an external advisor. That means that they can also engage a lawyer or a financial expert, a pension expert, or an organizational expert. The Works Council or the expert needs to inform the company in advance of engaging such an expert and to inform the company about the costs, which need to be reasonable. But if this is done correctly, those costs need to be paid by the employer. So that's good for you to know that falls within the scope of the Works Council's rights, and that also applies to if a Works Council eventually decides to go to court, then those costs, if brought up before the court case is started, then those costs are also for the employer to pay and not for the Works Council. Of course, it's also possible to have a discussion maybe with the Works Council if the Works Council want to engage any experts, for example, financial expert, that you can also discuss with the Works Council or make available to the Works Council any internal experts from a finance department, for example, to first see if they can assist or help the Works Council with any questions that they have before engaging such an external expert. The right of advice. The Works Council needs to be involved, for example, in the following intended decisions: transfer of control of the company, closing of the company, major reductions, increase or changes in activities of the company, major changes in the organization. That's a little bit a broader intended decision, but it is eventually one of the topics which is mostly used for a request for advice, but also major investments and commissioning an external advisor for a matter on which advice must be sought by the Works Council. So if the company engages an organizational expert to assist with any major changes in the organization, which is most of the times a reorganization or restructuring of the organization, then the law includes, the Works Council Act includes that you should engage the Works Council and ask the Works Council for advice about the engagement of such an expert. As you may have noticed in the last slide, it was included that the Works Council need to be asked advice about an intended decision. And that means that the decision cannot be final the moment that the Works Council is asked for advice. So that means that the Works Council needs to be timely involved in any intended decision that the company would like to take. For example, reorganization. The reorganization cannot be final the moment that the Works Council is asked for advice. So it's important to timely involve the Works Council, but I also know from my practice that is in a lot of cases quite difficult because decisions are made abroad in headquarters, for example in the US, and then after those decisions, which also involve the Netherlands and maybe other countries, companies in other countries within the group, they are then sent towards the Netherlands, to the director in the Netherlands, and then the director needs to execute those decisions. And that is quite difficult if you need in the Netherlands to follow a correct Works Council procedure and process in which the Works Council needs to be involved in timely, and it should be an intended decision. So Article 24 of the Works Council Act therefore includes that the Works Council needs to be engaged or involved at a moment when the intended decision also already is a plausible scenario. So that means that if there are any signs, any thoughts, more concrete than only a random thought, but if preparations are taking place, then the Works Council already needs to be engaged on such matters and need to be informed about such matters so that, for example, process arrangements can be agreed upon. One of the topics in which we see a lot of times that it also goes wrong is that when I mentioned the right of advice regarding external advisors, that external advisors are already engaged, maybe abroad, but maybe also by the Dutch company to advise on our organization, and then afterwards the Works Council is asked for advice, and then there is the advice refers to any reports or advices from external advisors. And you need to be keen on that. Also, if those advisors are engaged abroad, that if it has a direct effect on the Dutch organization, in principle, the Works Council needs to be asked for advice. And lastly, the Works Council needs to be asked for advice when it can still significantly influence the intended decision. So, and that is also quite a important thing to keep in mind, that if the Works Council cannot significantly influence the intended decision, so in other words, it's a final decision, then that could have serious consequences for the execution of, for example, a reorganization. So, because when the Works Council cannot significantly influence the intended decision, or the process is not done in a correct way, then the Works Council, as I mentioned already, in the Netherlands, has quite some powers. For example, the Works Council can give a negative advice. And if the Works Council gives a negative advice, that means that a 1 month waiting period is applicable if the company does not follow up the advice from the Works Council. But let's say the Works Council gives a negative advice and the company does not want to follow that negative advice, to not restructure the company as intended, then a 1 month waiting period is applicable. The Works Council is informed about the company's decision to not follow that negative advice. Then the Works Council can even go to court in the Netherlands and to ask court to stop any implementation and to ask court that within all reasonableness the decision to continue with such a reorganization is not possible. So that those are quite serious powers and can have serious consequences for the process, especially in a global perspective or an international perspective, that in the Netherlands the process can be obstructed and can have consequences also for other countries. So the key takeaways from this point, this topic, are the Works Council needs to be involved timely in the process. Also to discuss that if you are in an international organization with your stakeholders abroad, and if the Works Council is not involved in a timely manner, this could lead to delays in the process or even legal procedures, such as a negative advice, or if we're talking about Article 27, that the Works Council does not give consent, and then a whole different legal also procedure could become applicable.
Yes, thank you, Julien. Then I will continue with the next topic, which is dismissal for underperformance. We get many questions in our practice about this because the Netherlands is known for a difficult termination procedure. We are the only ones in Europe who have this system where the employer cannot just give notice, but the employer should either go to court to request termination of the contract or reach a settlement on termination with the employee. So I will give you some more insights on how that court procedure would work, so you better understand your alternative if settling with an employee is difficult. So you can request the court to dissolve an employment contract, and the court will agree with that if you can substantiate reasonable grounds for termination and if reassignment to another role is not possible. So such grounds may include unsuitability for the work, which cannot be related to illness or the working conditions or a lack of training. So not performing could be a ground for termination, but you also have to ensure that you have warned the employee about the underperformance, that you have given sufficient time and support to improve. So for instance, by offering a performance improvement plan with some training or a coach or coaching on the job to support the employee to improve. If that's not happening, that improvement, you could put forward unsuitability for the work. Another ground is a disrupted working relationship, which often also happens when there is a discussion about underperformance. We usually see that if there is a lot of negative feedback, this also affects the working relationship. So a disrupted working relationship by itself could also be a ground for termination. And finally, a combination of the above grounds can be put forward if you want to dissolve the employment contract of the employee. And that can be useful if your underperformance file or your disrupted working relationship file is not completely sufficient. But in the end, there is still an unworkable situation. So if the court agrees with termination of the employment, the court can award certain payments to the employee. So to start with, the court will observe the notice period, which means that the end date of the contract will take into account the notice period of the employee. So depending on what is agreed in the employment contract or the statutory notice period, depending on the seniority of the employee. The court usually also grants a transition allowance, which comes down to 1 monthly salary for every 3 years of service, calculated pro rata. The court could also grant a cumulative compensation, but only if the court terminates based on the combination ground. And that cumulative compensation can go up to a maximum of 50% of the transition allowance. And finally, the court can grant a fair compensation. This is an uncapped amount and can be substantial. But it will only be granted in cases involving seriously culpable conduct of the employer. So it's not easily granted, and the employer should really have done something very wrong to get this compensation. So of course, even though a settlement is a preferred option, it's advisable to understand what the leverage of the employee is in the negotiations, and that will depend also on the potential outcome of a court case. The main risk for the employer of a court case is that the court rejects termination and that the employee remains employed. That, of course, creates quite some leverage for employees where the dismissal file is not really sufficient. Another risk is that the employee will agree with termination, or the court will agree with termination, but a fair compensation, which can be a substantial amount, is granted on top of the transition allowance. So it's important to, when you negotiate with an employee, to weigh what the expected outcome of a court case will be, because that will also play a role in what you're willing to pay this employee under a settlement. Therefore, I prepared an example court case of a very recent court decision in Rotterdam in April of this year, for you to give some more insight in how such court case goes. Well, this employee was employed since 2008 as an application manager, and there were ongoing issues with attitude and performance since 2020. an improvement plan was successfully completed in 2023. So the employee stepped up, made an effort, and was able to successfully complete the performance improvement plan. And the company communicated, okay, then we'll start over now with a clean slate. But then shortly after, colleagues complained about the communication and attitude and the cooperation with this employee, and they saw that this improvement was not sustainable. Therefore, the employer decided to request the court to terminate the employment due to underperformance or disturbed working relation, or a combination of these grounds. Of course, if you go to court, you will try to get the termination, so put forward all the grounds which could be relevant. Well, what was the court decision? Well, the court says in terms of underperformance that the past improvement was completed and that the employer was not able to prove new complaints or underperformance, and therefore that the court could not say, okay, you've met this ground, or this ground has been substantially substantiated. And also the same applied to the disturbed working relation. The court acknowledged that the working relationship was tense, but the court said that insufficient efforts were made to restore it. But the court did agree with termination based on the combination ground, because the court acknowledged that an unworkable situation has arisen, and that was because there was a lot of discussions between them. The court also said that the employee had a lack of self-reflection and didn't really see the impact of his own behavior on colleagues, which made it unlikely that this situation would improve and change. So, also both parties already agreed that there was no suitable alternative position for this employee. So that was not a debate in this court case. I have to say that is often a debate in other court cases, because the employee can put forward that no alternative position was investigated and maybe there is a suitable vacancy. And that then also needs to be addressed by the employer, why that would not be suitable in such court case. But in this case, this was not a topic of debate. And the court ruled that the employment contract will be terminated, that the transition allowance will be awarded, and that an additional cumulative compensation of 30% needed to be paid. And that's because of the termination based on the combination ground, that the court was able to grant a cumulative compensation. The court didn't award the highest percentage of 50%, but only 30%. And that was because the employee was already on work exemptions or garden leave for like half a year. And the court took that into account when granting this compensation. So the key takeaways of this topic are that it's important to monitor and document sustainability of improvement after the end of a performance improvement plan. So don't just stop completely with it, but have a close look on the sustainability of the improved behavior, that it doesn't only apply during the PIP process. A key takeaway is also that you have a responsibility to work on restoring a relation in case of a disturbed relation. And the disturbed relation could take place because of underperformance, which affects the work relationship. And then you could consider using mediation to work on restoring. Perhaps you resolve the issue in mediation, and if not, you have at least demonstrated efforts made to restore it. Also, the cumulative ground is a useful ground in court when the situation becomes unworkable, because these grounds give the judges some space to terminate, even though the other grounds may not be fully substantiated. An additional compensation must be paid, but is usually modest, because the transition allowance by itself is usually not a very high amount. So if you, of course, you prefer a settlement agreement and avoid court proceedings, we totally understand and agree with that. But court proceedings can provide a useful alternative if settling is not possible. Julien.
Thank you. Another topic we wanted to discuss with you today is employer liability, because employer liability, hopefully not everyone has to deal with it or have dealt with it, but it is still something to be aware of. So the Dutch law includes that as an employer, basically, or as a client, hiring in temporary agency workers or workers not employed by your company, that you are responsible for the workspace, tools, equipment, but also for the instructions to prevent, as good as possible or reasonably possible, damages. And that also applies for employees who work from home, and to prevent any damages at home. That obligation goes not that far, but as in the office, for example, but still you have a responsibility as an employer. And this is, of course, the employer's responsibility to take care. This is particularly important when it comes to tools that by their very nature pose a safety risk for employees. So what can maybe reasonably be expected from you as an employer? Of course, that depends on the circumstances of the case, such as the nature of the work, knowing how dangerous the work is, the chances of danger occurring, and the seriousness of the consequences. As I mentioned, it depends on the circumstances of the case. So these topics or these points are quite broad. And as an employer, you're not liable if you can demonstrate that you have fulfilled the obligations to take care, or when the damage is largely the result of intent of the employee or deliberate recklessness on a part of the employee. Also, of course, you're not, as an employer, you're not liable if these are generally known dangers. For example, when an employee cuts his hand using a bread knife or something like that. Firstly, the employee needs to prove that he has damages following the work that he has performed, and then the employer needs to prove that he has fulfilled his duty of care. And to take a further look at this legal framework, I took a look at a recent court case from the Court of Appeal from March of this year. It's about an employee employed by a temporary agency and working for a client who fell off a staircase, an A-stair case, as shown on the picture as well. So what happened in this court case? It's about a service technician who worked in 2021 already for a client and fell down stairs when he was replacing blinds at the supermarket. So what I mentioned already, the accident happened in 2021, and this court verdict from the Court of Appeal is from 2025. So these kinds of cases, also if it's even about falling down of a staircase, can take a lot of time and cost a lot of effort, of course from the employee's side, but also from the employer's side. What I mentioned, the service technician was busy replacing blinds at a supermarket. He got out of balance and fell with the stairs and broke his ankle. Had 2 operations were necessary to fix his ankle, and then in the end of 2021 he kept the employer or the client liable for his damages. This was firstly denied by the insurance company from the employer of the client, And in the beginning of 2022, the labor inspection was also involved because of this accident. And the labor inspection eventually concluded that no violation of the Working Conditions Act was the case, and included that in a report. Then the court case also includes that quite an extensive statement from the colleague with whom the employee or the person who fell down the stairs was working with. If I'm reading that statement, I can only think this is drafted by the legal counsel of the company. The gentleman fell down the staircase. It was denied by the insurance company, and eventually the employee went to court. And at first, his claim was denied. So then he went, or maybe I think also his insurance company went to the Court of Appeal to continue to claim that the client was liable for the damages. So if we take a look at what was brought forward by the client that the client has done to fulfill his duty of care, the following was brought forward. The staircase was not defective and was suitable for the work to be carried out. The employee was well trained and aware of the manner in which the work had to be carried out safely. No additional instructions were necessary because of the height. It was less than 2.5 meters from the ground at which work needed to be done. The client had a personnel manual which generally refers to safety rules for working at a height. Safety instructions are given through regular physical safety meetings with the employees, toolbox meetings, and a report was drawn up for those meetings and sent to the employees. As I mentioned, this was the end of 2021. So a specific detail of the matter was that the safety instructions in person were not possible because of COVID at that time. Despite the fact that those safety instructions were regularly given, at that moment in time, that was not specifically possible. So if we take a further look at the court verdict, the court summons up what hasn't been done, because the client couldn't prove that the employee received the personnel handbook via the temporary work agency. It could show that they sent the personnel handbook to the temporary work agency, but they couldn't prove that the employee, the worker, eventually also received that, and he denied also that he received the personnel manual. The personnel handbook also didn't include specific instructions or safety rules for working on the stairs, only safety rules working at a height of more than 2.5 meters. And the client was not able to prove that the safety meetings were held regularly because also of COVID, and that the employee was able to attend such meetings. Based on these conclusions of the court came eventually to the conclusion that the client has failed to give appropriate measures and give instructions. The client also had failed in his duty of care. It was without a question between parties that the employee's damages were the result of his work, of what he had done during his work. He was not reckless, and it was not his intent to fall down the stairs. And also the fact that the labor inspection was unable to establish a link between a violation and the Working Conditions Act did not alter the court's judgment. So eventually the court decided that the client was liable for the damages of the employee, despite all of the measures that the client already took care of. That wasn't enough. So what this court case also shows that you need to be aware that the duty of care of an employee reaches quite far, also for hired temporary agency workers, and that you need to ensure that documents relating to safety at work, and that also applies to working at an office and all the safety measures for working behind a desk and behind a computer, are communicated to the employees, and that you should be able to prove and can provide that the employees receive those documents, and also to regularly check if any safety measures are still up to date, and that every employee is made aware of these updates regularly, and that you can actually prove that you updated those safety measures and communicated that to the employees. So, and we are sitting here as lawyers, Sanne and I, so we like to have things in writing for such cases. And eventually that's also important when such a case goes to court, because of the insurance companies who will continue to pursue such cases.
Okay, then we will go to the questions, because I saw some coming up here in my screen. Maybe to start with the question about the last presentation for you, Julianne. The question is, our company does not work with ladders or heavy machinery because we mainly work in the office. So what can be expected from us to avoid liability?
Yeah, good question. As I already mentioned, I can imagine that not all of the companies who are attending this webinar are indeed working with ladders or heavy machinery indeed. Also with the Working Conditions Act, you need to have an RENA in place and to regularly update the RENA, and if it's updated, that it is what I mentioned already, communicated. So, and maybe there are specific safety hazards in the office, staircases or something like that, that you need to, that you take care of that, those specific things, and have in writing again on the internet or by email to the employees that you make them aware about those safety measures and hazards within the office.
Yeah, and of course, like the basics from office work are screen work, so sitting in the right position and providing maybe glasses to employees who are not able, who otherwise would have hurt their eyes in case of screen work. But also psychosocial distress. So if from your RENA, like Julianne explained, this is the risk inventory and evaluation. There we see that there is a lot of high workload. It's important that you address that topic in terms of working conditions and make an action plan also because of that. So yeah, those topics are general topics, which of course also apply in the office. Okay, here another question. Is it correct that 0-hour contracts will be prohibited in the Netherlands and that it will be less flexible to work with temporary agency workers? Well, that was exactly what indeed was in the news today, that the government is planning to prohibit 0-hour contracts and to also limit the time that you can work flexibly with temporary agency workers, as well as make it less attractive to keep offering fixed-term contracts to employees. So these are indeed plans of the government. It's not in force yet. We still need to see the actual legislative proposal. It still needs to go through Parliament and the Senate. But again, like actually the former governments, it is again the plan to reduce flexibility in terms of contracts for employees, to protect employees who are not able to, in the end, get a permanent contract. Okay, then let's see here. Another question about works councils. Is it possible to correct any errors in the works council process? So, for instance, if the works council was not timely informed, what can you do as a company?
Good question. If an error occurs, then of course the error occurred, and then it's difficult to correct that. Over the last couple of years, in my opinion, the courts are a little bit more flexible than, let's say, in 2016, when two or a little more court cases were brought forward. And nowadays, the court states that you are, let's say, 1-0 behind. But if during the consultation process, the Works Council indeed gets genuine possibilities to have significant influence on the decision. For example, if they were not engaged about an external advisor, it could be repaired, and eventually the court could decide that despite those errors, the Works Council still was able to fulfill its task, and then that would not make it reasonable for the court, for example, for a Works Council to give a negative advice. That was a little bit stricter a couple of years ago, but I think, in my opinion, that has become a little bit more flexible.
Okay, so it can be repaired as long as you ensure that there is sufficient influence in the end.
And of course, it depends on the error. How big of the error, of course. Yeah.
Okay, let me see. I think this is the last question. Is it possible to offer an underperforming employee a settlement agreement before offering a performance improvement plan? Yeah, so this is a question which comes more often in our practice, because when an employee is underperforming, often employers know, okay, will this employee succeed in a performance improvement plan, or is there really a good chance, or do you know it will not succeed anyway? Can you then also offer a settlement agreement instead of a performance improvement plan? Well, this is a risk, because if in the end you won't settle and need to go to court, the court can be critical about this, because you may not have given the employee a fair chance to improve if you have started with offering a settlement agreement before offering a PIP if you're not able to settle. However, we've seen in our practice that if you offer the employee the choice, like, would you like a settlement agreement or a performance improvement plan? If you choose the latter, we will definitely support you in that. So not one after the other, but at the same time. Usually we see that courts are okay with that, as long as it's clear that the employee would still get a fair chance to improve, and you only offered the settlement option to put this option on the table for the case the employee would prefer this option, which is sometimes also the case, because for employees, a performance improvement plan is not always a pleasant experience as well.
So you really offer it as an alternative.
Yes,
and
exactly.
You say the PIP is the main priority of us, but as an alternative, we are willing to offer a settlement.
Yeah, and not like one after the other. So start with a settlement agreement, and then only if you will not able to settle, start the performance improvement plan to build up your dismissal file. So it needs to be, you need to do this in a careful way to respect the employee's rights, and not to be 1-0 behind when you need to start a court case. Okay, I think this is it. And let's see, now another question comes in. In relation to the court decision of March 25, what was the role of the actual employer of the employee? Is the employer also responsible, not only the client? So this is about the employer's liability.
The employer's liability, the temporary agency, who is the formal employer of the employee. In this case, the technician only started a court case against the client, because the client was also responsible for the work. But it is possible also to hold the formal employer liable, because they are both liable for those damages. Can be kept liable for those damages.
Yeah. So the employee can choose who he considers most easy to sue, or who he thinks is the most financial security to pay the claim. That's of course important.
Good question.
Okay, well, those were all the questions we saw on this screen, at least. If there are any other questions, please feel free to get in touch with us and email us. And then we would like to request you to fill out the webinar evaluation, which will show up in your screen once we end this webinar. And then we only would like to thank you for attending this webinar. We hope you enjoyed it and that you will join us the next time. Thank you and good evening.